we got Lady Justice Asplin on the phone?
Lady Justice Asplin, the Master of the Rolls asked if you can hear him.
I couldn't hear him at all.
You couldn't hear him at all, okay.
Can we, is there somewhere else we can put it? Right, thank you. Yeah, let's see, let's see. Put you on there.
We're going to see if we can move the...
Well, the range of those things is not great.
Right, well, I think we have to... Can you hear me now?
Yes, thank you.
Right, everybody will have to speak up. If you can't hear counsel, will you please let us know, and we may have to reposition the spider phone.
Thank you.
You'll have to adopt your most stentorian tones, Mr. Wilson.
I'm sorry to the parties we're in this situation, but I'm afraid it's going to become more and more common, I fear, as time goes on, and so we've got to use such technology as we can if people want to continue with their cases. And it seemed to me this morning that really it was essential to finish this case, since we're so near the end in any event.
Lord, respectfully, yes. My lords and my lady, what I'm going to do, having read yesterday's transcript, and I hope my lady can hear me.
Yes, thank you.
Having read yesterday's transcript, it seemed to me that I'd actually covered some of the main points. So what I want to try and do this morning, and I'm conscious that the Master of the Roll said yesterday morning that not every point needed to be responded to on every side. I'm going to try and focus my submissions on what seemed to us to be the main remaining points, and try for brevity as well as a stentorian delivery. At the end of yesterday...
Can I ask a question?
Yes.
That has been in the back of my mind for quite some time, but I really forborne from asking either Mr. Railton or you about it so far, out of fear that it was not a particularly good point. But anyway, even if it's not a good point, I think sometimes one has to raise it. And it really ties in, I think... Yes, and that's because she's got the live stream. The live stream's got a 90-second delay. Right. Right. Lady Justice Asplin. Hello?
Hello?
I think there's a 90-second delay on the live streaming. So what I think you're getting there is through the live streaming, the delay in what we were talking about. If it's distracting it's up to you what you prefer. If it's distracting for you, I would turn off the live streaming.
Actually, as the quality of sound on the telephone is so very poor, and it is so much better on the live stream, I think I will just be 90 seconds behind and just use the live stream.
Do you want us to stop the telephone line then?
Well, I don't know you can do that because she has
I'd
to
like it if you could
participate.
try to do something with the telephone line because the quality is very, very poor at this end.
What about turning it down to
I'm very sorry.
Well, I'm just concerned that you should have the opportunity of asking any questions.
Yeah.
Just from experience from other telephone conferences, if respectfully Lady Justice Asplin might mute her telephone when she's not speaking, yes, then we won't get the feed that we were getting from 90 seconds previously.
I don't know whether you heard that, but if you could mute your telephone when you're not speaking, we won't get the feedback from the telephone. Good. So can you mute your telephone?
Okay.
Well, let's go. Anyway, I think it relates to the point that you were making yesterday about the fact that in the condition 3 waterfalls for capital interest, you get to the stage of the, I think it's the SIT, the point at which the SIT has been reached. So in both those waterfalls, there's a state where the SIT is reached, and then it tells with and then you get to what goes to the Class F Noteholders. at that point.
The first bit that goes to the class.
The first bit that goes to them, and the relevance of that is that the SIT marks it reflects a return, a level of performance. It reflects a level of performance that's been reached by the collateral manager at that point. And your point was that you don't have anything similar in the condition 11 waterfall, and you made a number of points about that. It was not simply that point, but there were some other points tied to it. Now, one of the points that I've been rather perplexed by is this in relation to performance, that under the condition 11 waterfall, after there's an issue about the significance of taking into account V, for example, which is redemption of the notes in full, taking that into account in relation to the calculation of the CMF. And there's a debate between the two of you about how significant that is. But what I'm slightly perplexed about is this. The redemption of the secured income note, the Class F notes, doesn't denote any kind of profit at all or performance. It's simply getting your capital back. And so what I'm perplexed by is why, I mean, it may be about that from Mr. Railton, but it may be a very facile question. But I would have thought that if you're looking at performance and you're looking at return, you're looking at the return you get over and above, as it were, what you've actually paid for the notes themselves.
I hope I've understood my Lord's question. Can I give my Lord a very short answer now and a slightly longer answer towards the end of my submissions? Because I think I'll be able to give my Lord a better answer, showing my Lord two documents which are in the papers as to how the note issue actually performed and how it would have performed if the over-collateralisation tests had not been failed. Right. The very short answer now. My Lord shouldn't think about these notes in terms of principal and interest in what you might call the traditional sense, in the sense that you give £100, you put in £100 and you hope you'll make 5% a year. And the 5% of year is your profit, but you expect to get your £100 back. These notes don't work that way, because these notes, the interest is not a 5% interest. It's what is left from the underlying loan portfolio, which underlies all these notes. You have a whole load of loans. They are either being paid or defaulting, and they are throwing off income. Yeah. And that income is being used to pay the various notes. Let's say at the end of the first year, I'm just going to throw some figures out just to illustrate my point. Let's say at the end of the first quarter, the Class F noteholders receive £13 by way of interest through the interest waterfall. The next quarter they might receive £12. The next quarter they might receive £15. It goes on and on. The income to the Class F noteholders is their main level of what my Lord called profit, their main return.
We discussed that, yes.
Yes. There is an inbuilt assumption that quite a lot of these loans are going to default. Yes. The way the numbers work is that if the notes perform, and I'll show my Lord this on the papers later, if the notes perform, so to speak, as anticipated, and when I say as anticipated, I just mean using a normal model, absent a 2008 financial crisis, you will get to your 10% IRR from what we are calling in this case interest distributions after a number of years, and I'll show my Lord how long. That's before any principal has been repaid. In other words, after a number of years, I as a Class F note holder, let's say I put in 100, my class, I'll use the figures in the case, 52. Yeah. So whether I get my principal back at the end of the notes issue is at that stage extra profit to me, it's not, as my lord says, something which I'm banking on. And why should that be relevant?
No, but you spent that. You spent that for the investment. That's your money you had to spend in order to get the note.
But on this analysis, I spent 52. After, say, 4 years, I've received in total interest payments 75. And that's given me my 10% IRR. And what is my 10% IRR? My 10% IRR is my capital back and 10% a year. That's what IRR means. In other words, by that stage, I've already got my capital back. And therefore, anything I get at the end of the transaction, when the notes are redeemed, is, so to speak, extra. Because...
But that still
But
produces...
isn't it the case, though? I mean, this comes out of a submission that you were making yesterday, which is that it wouldn't... one of the principal differences between the condition 3 waterfalls and the condition 11 waterfall is that in the condition 11 waterfall, the accrued and unpaid ICMF, which is, you say, from the past, is in priority to payment to redemption.
Yes.
And you said it would be very odd, it would require writing in a new W for there then to be, as it were, a new ICMF before you got to the interest. And I think, in a sense, the point my Lord's putting to you is supportive of your case, because it seemed really to both of us that when it comes to redemption, I mean, however much the redemption is, if you're talking about early redemption, optional redemption, you might or might not get your 52 million back.
Well, you won't.
But whatever you've got back is not profit.
Well,
it's not profit.
It's not
either your original investment or a proportion of your original investment.
The problem is words like profit are
I understand.
perhaps a little unhelpful in this context. Yeah. But certainly it's not profit in the sense that it's not, so to speak, it's principal and not interest. It's not profit in that sense.
Yeah.
The problem with using words like profit is that when you're talking about IRR, it's all really about
return.
time.
I don't mind if you use the word return.
Yes.
That's fine. It's a return. Anyway, if it's a bad point, which you seem to think it is, which is fair enough, I've asked the question. I am slightly mystified because even if you taking what your explanation, which is that in the course before redemption of the operation of this note transaction, of this subordinated loan transaction, you are receiving an amount in the IRR, which, as you described it, both includes repayment on the 75 million of your capital. That element is not a return. And you can't describe something which is. I mean, I wouldn't, in my naivety, I wouldn't describe the return of what you've paid, whenever it comes and however it comes. I would not have described that as a return on my investment.
Yes.
It's as simple as that.
Yes. On that point, respectfully, my lord is correct. And
that's a reason why, amongst many other reasons you would submit, there isn't a new W.
Precisely. And of course, we have to remember, during the course of the transaction, although we can think about odd scenarios where the Class F noteholders will get significant repayments of principal, the Class F noteholders only get principal through the principal waterfall once everybody else has been paid off. So, in the real world, that's not going to happen in reality. You can think of odd circumstances where it might, but in the real world, it's very unlikely to happen during the course of the transaction. Because for the Class F noteholders to get principal repaid during the course of the transaction, everybody else has got to be repaid as well.
Anyway, you don't want to take up my rather brilliant point, which is...
My lord, the reason why... I'm going to leave it there because I can't make it any more brilliant than it already is.
Which is V is described as redemption of the notes.
Yes. Well,
that's fine.
I'm not certainly moving away from my lord's point. And insofar as it's consistent with what I submitted yesterday, I respectfully adopt it. I hope that's both sufficiently stentorian and obsequious.
Very much.
Now, just to pick up, if I may, quickly, where I was yesterday, and we were finishing off my submissions on the threshold and aggregate distributions to the Class F Noteholders. I made my submission, I think, that the word aggregate distributions to the Class F Noteholders itself doesn't take us any further. That just begs the question as to what is included in aggregate. My learned friend made another point, which is by reference to the principal waterfall in condition 3 at page 155 of the core and 374 of bundle 2.
155.
155, my lady.
Okay.
And my learned friend's point was this, that looking at Z, where you pay principal until the Class F secured income threshold has been reached, told us, he said, that indicated that principal as well as income should be taken into account in calculating whether the threshold had been satisfied. With respect, that is not correct. The waterfall, as has been said a number of times, only tells you when to pay ICMF in the waterfall, assuming one is payable. It doesn't tell you whether an ICMF is payable or how the threshold is to be calculated. That is only available from the definitions. And the way this works is this: when you get to Z, if an ICMF is due because Class F noteholder receipts, including interest on the instant payment date, has met the threshold, you pay ICMF at BB. If not, you don't. So the reference in Z does not enable my learned friend to step outside of what we submit as the clear definitions in the operative, the clear words in the operative definitions. The last point I should make is...
So just so I understand that
Yes.
point, Mr. Wilson, what you're saying is that when one looks at Z, it's simply looking, as it were, at the financial position.
Precisely.
What it's not doing is saying that the principle is within the secured income threshold.
Precisely. The threshold has its
It's
own...
looking at the figures.
has its own definition, has its own. It may well be that Z is rarely operated. That'll again just depend on the way the figures pan out. But it can't override the clear definitions of what the threshold is. The last point I should make in this context is my learned friend's submission in his written argument at paragraph 63.1 that a commercial party looking at the IRR threshold would, to use his word, naturally assume that principal on the instant payment date would be included. And with respect, that sort of submission takes the point no further. We submit that a commercial party would naturally assume that in order to work out whether interest or principal or both or neither are included when paid on that instant payment date, the commercial party would read the documents. So it really just, in my submission, takes us back to the documents themselves. So those are my submissions on the threshold point. And I hope the court will permit me if I just, so to speak, signpost my submissions a little more this morning than I would normally do because my lady's on the phone. I'm now going to move to a different point, which is the Collateral Manager Termination Amount, the CMTA. I'm going to try to take this fairly quickly because I think I mentioned one of my main submissions on this yesterday. To get us back on the point, this is a new point run by my learned friend, and the submission is essentially this, as we understand it. CMTA, he says, by reference to clause 18 of the Collateral Management Agreement, which we find behind tab G, starting at 181 of the core bundle, page 585, in the main document.
Sorry, so sorry, which, in the core bundle, where is it?
Core bundle is behind tab 13G, starting at 181, right at the back.
You haven't. Oh, I see. You haven't got this in volume A of the core bundle.
No, I mean in A. Sorry, tab G. Sorry, tab 13. After my tab 13,
Right at the
I've
end
got
of
A,
the
B,
full
C, D, E, F, G. With where the clauses are, my lord.
Yes. 185.
181. I've got a little tab G before that.
Yes, the,
Yes, 181.
So this is where we find the CMTA clause, and we know that CMTA, if we can turn to clause 18.8, CMTA is paid if the collateral manager is a Babson company, square brackets Barings, close square brackets, and is terminated without cause. And importantly for this submission, we know now, as learned friend told the court yesterday after lunch, that Barings was the initiator of this transaction and reached out to banks to appoint the arranger and others. Now, my learned friend's point, as we understand it, is this. He says, if you look at 18.82b at page 185, CMTA is paid on each payment date. And he says that includes a payment date when the condition 11 waterfall is run, i.e. a redemption date. It's not limited, he says, unlike the ICMF language, to condition 3 waterfalls. And it would be very odd, it's really an analogy point, it would be very odd, he says, if CMTA was payable and ICMF was not. That's the point. Now, my main submission in reply...
Well, because he said that basically the return point is, in economic terms, replicated identically or very similarly in 18.8 to A.
Precisely.
I'm sorry, you disappeared, Wilson.
Oh,
Thank you.
I-
You said he said it's odd if the NPA is paid and not ICMF, and then I lost you.
the Master of the Rolls put to me, because essentially the commercial effect, this is my learned friend's case, the commercial effect of 18.82b is similar, or the same as my learned friend would say, to ICMF. That's a point, as I understood, that the Master of the Rolls put to me, and I was just about to agree in part, because our first submission in response is that it is not economically the same. Because one of the important points about ICMF, and I go back to what I said right at the start of my submissions, is that if it cannot be paid, it can be deferred. CMTA cannot be deferred. There is no deferral provision, and given that there is an ICMF deferral provision, the absence of such a provision for CMTA speaks even louder. In other words, it's not that you could, so to speak, try to write one in if everything else was silent. Everything else isn't silent. The draftsperson here knows about deferral provisions. We saw that in clause 14.1. There is no deferral provision for CMTA. And we can see in the language, if we want to make a linguistic point, in 18.82b, subject to clause 18.83 below, on each payment date, the issuer shall pay such Babson company. One can compare that to the language of payable, which we often find with ICMF. But in any event, there is no deferral provision. When one looks...
18.8.3 says if you haven't reached the threshold, then you don't pay.
That's precisely the point I was coming to. The last words on 18.83 are inconsistent with the deferral. Shall not be paid on such payment date.
And there's no provision that says, but they shall be paid later.
And remember, and it wasn't just that the draftsman had turned his or her mind to deferral. The draftsperson had turned their mind to deferral and interest.
Yeah, I know.
So that's the first thing. So once we have a material, and this is commercially very material, distinction between CMTA and ICMF, the analogy fails. And
Well,
that's...
the whole point really is that termination with cause is effectively misconduct or serious breach of the contract. What might be described as general sort of discontent or malaise would entitle you to terminate the collateral manager without cause. But you're only in real terms going to do that if you're dissatisfied in some way, and therefore the portfolio isn't running all that well. So the idea that that in fact the collateral manager who's been terminated is really going to have this CMTA, as it were, quarter on quarter in perpetuity is unreal.
Well, if I may, I would take that point and put it a slightly different way, if I may.
Yeah, sure.
The oddity about this termination, and I respectfully adopt the first part of what my lord said, that with cause termination here is really when the manager's done something pretty bad.
Yeah.
Willful default, acted improperly, we can see those provisions.
Yeah.
If you find out there in the market that there's a manager who could do a better job, or do the same job but much more cheaply, that's not with cause, that's without cause. And the odd effect of the CMTA is that if you were to bring in a new manager, and the new manager does a great job, Barings having done a pretty rotten job, under the CMTA, Barings gets all the benefit of the work done by the new manager, because they get I think my Lord the Master of the Rolls made this point yesterday. So this is why I mentioned that my learned friend accepted, having taken instructions in response to a question, that Barings is central to this transaction. Because what the CMTA is, and this is really my second main submission on CMTA, CMTA is a legal landmine to stop you firing the collateral manager. That's really what it is. And it's been drafted, if I may say, my learned friend gave credit to the various firms' solicitors yesterday. Can I say this has been drafted very cleverly? Because it doesn't get you into the problems of penalties or anything like that. It's just a provision. But when you work out what it means commercially, it really means that they are unfireable.
It's the equivalent. It's the equivalent in the share terms of a poison pill.
Precisely.
That's basically what it is.
Exactly. And we see that in a number of ways, not only because the point I just made, that they get the benefit of the work of the new manager, if the new manager does a good job, but also to pick up the point I think the Master of the Rolls made yesterday as to the fee. Now, we were looking at the 0.2% fee. It's 0.2 of the aggregate principal balances. We can put that in context because, and if I could just ask the court, I think this will be the only time, I think, to look at a point in the witness statements. It's the only way I can get this point before the court. If one takes bundle C and goes to tab 2, which is the first witness statement of Mr. Falconer. And I don't know whether my lady has all her files with her, whether I should read this bit out into...
I only have bundle A.
Well, I hope my lady, if the court here will forgive me, just reading a very short paragraph so my lady hears. If we look at page 20, this is a passage where, if we turn back to 19, there's a heading, Introduction to a CLO Transaction, and Mr. Falcon is explaining how it works. There's a large measure of agreement here, obviously. But paragraph F, sorry, I'll start at E. I'm now reading.
So what's the number? C/what?
See tab 2, page 20, at little e. The collateral manager is paid a fee for managing the underlying portfolio of financial assets. Typically, the collateral manager's fees are divided into a base fee and an incentive fee. Subparagraph F. The base fee is an amount equal to a percentage of the assets under management. For a Barings UK Limited managed CLO, originated at around the time of the transaction, a typical base fee will be in the range of 0.7 to 0.75%, based on the aggregate principal amount of the financial assets in the portfolio then outstanding. And then G, which I won't read, goes on to talk about the incentive fee. So we can put the 0.2 in context. The 0.2 was less than a third of part of the fee, which Barings at the time regarded as, if I can put it this way, what it would take to get Barings out of bed to be the manager of this transaction. Barings wasn't going to do it for less than that, says Mr. Falconer. So that puts the 0.2 in perspective. Now, of course, as we touched on yesterday, you could commercially find a collateral manager who wouldn't do it for 0.2 but would do it for 0.75 and an incentive fee. You could do that, but what are the consequences? You've got to rewrite the waterfalls. You're basically paying twice, 2 incentive fees. And who ends up paying? Well, the people who hold the bottom line, i.e. the Class F noteholders. So not only is this CMTA with respect to a bad point from a learned friend to take now, because it is a flawed analogy, but actually it supports my case, because what this shows, it's a good example of another commercial bargain present in these documents. Here we have a bit of a commercial bargain which is very valuable for Barings and potentially very expensive for my clients. And in my respectful submission, it goes back to the point which I was discussing yesterday, I think with my Lord Justice Flaux, as to the dangers of applying commerciality, that you can't even look at one particular commercial point and say, is this commercial or not? Because there are swings and roundabouts, there are checks and balances all over this documentation, and the CMTA is, in my submission, a good example of that.
So it might be said that it's there's a quid pro quo there that's a fairly obvious one. On the one hand, if the transaction is going to continue and you don't like Barings, you've got this situation where economically it makes no sense at all. So that's, as you put it, makes them pretty well unsackable. You can see that point. But on the other hand, if you decide that you want to actually terminate by an optional redemption, then as it were, the shutter comes down, and only what's been deferred but unpaid in terms of ICMF is still due, and nothing else is due.
Yeah.
So it's a quid pro quo.
Exactly, and well, with respect, yes, except I would actually say there's lots of quids and lots of quos.
Oh, I understand that
Yeah,
one, but
exactly.
it's just focusing on the two specifics, the ICMF and the CMTA.
You could make
They sort of
that.
counterbalance each other, don't they?
You could. And of course, one of the points, talking about the shutters coming down, one of the points which I'm sure the court has got is, even on the learned friend's case, there's nothing to stop the Class F noteholders having an optional redemption if they work out, for example, that even if my learned friend is right, that a new ICMF is calculated, and even if my learned friend is right that it's principal as well as interest, it'll get to 9.97. Even on his case, there's nothing to stop us doing that. So the fact that we could operate such that the collateral manager wouldn't get a redemption, an ICMF, is, so to speak, built in. Now, commercially, as I'll show the court, that would make no sense, because commercially, the way this works is that if the assets are performing, we are getting we're getting enough of an income that even if we have to pay ICMF, we still make money. But the idea that you could, so to speak, arbitrage it, there are arbitrages built into this deal all over the place, and that point really doesn't take us any further. So those are my points on CMTA, which is the first of my learned friend's 2 new points for this court. The second new point, which my learned friend takes, is the condition 6 point, which is at page 162 of the core bundle.
Thank you.
Again, I can take this, I hope, fairly quickly. Just to remind the court what my learned friend's point is, as we understand it. My learned friend points in 6A Roman 2 to the absence of a reference to the condition 3 waterfall, to the absence of a reference to the condition 11 waterfall, even though the condition 3 waterfall is referred to, and says, but look, if you look at the condition 11 waterfall itself, Class F secured income, coupon interest, and Class F secured income deferred interest is included in the condition 11 waterfall. And so he says the fact that the relevant clause doesn't refer to the condition 11 waterfall when it refers to the condition 3 waterfall is not decisive. And again, it's, so to speak, a read across we should apply the same approach to the construction of the other clauses. Now, that, in my respectful submission, is also an incorrect analogy, and it's incorrect for two reasons. The first was pointed out, I think, by the Master of the Rolls yesterday, which is that if you read even just 6A2, that itself provides expressly that the interest will continue to be payable after redemption of the Class F notes. And after redemption of the Class F notes, you are in the Condition 11 waterfall. So the clause itself, it may not use the word Condition 11, but it tells you in terms that it's going to be operative in the Condition 11 scenario in any event. And I think that was a point made by...
But it's the last line and a half,
Exactly.
notwithstanding.
Exactly. That was a point made by my Lord the Master of the Rolls yesterday. And if I may try to respectfully buttress that point by inviting the court to look at 6M on page 168. M, it's the last clause, my lady, before clause 7, M.
Yes, I got it, thank you.
This provides for payment of additional Class F secured income interest on all payment dates as the surplus of income and gains over costs and expenses payable pursuant to the priorities of payment on such payment date. Now, the priorities of payment here are not limited to the Condition 3 waterfalls and would include the Condition 11 waterfall as well. So it's another way that you would know that you're going to be looking at this in the Condition 11 waterfall circumstances, as well as the last line and a half or so of 6A2. Now, just to make one point, because I wouldn't want the court to think that we don't accept that there are no infelicities in this document. There are, and while we're here, let me just show you one, because this is the sort of infelicity which we're used to in these cases, and we deal with. If one looks at clause M, you see in the third line, clause 6M on page 168, yeah, where we just were, third line, additional Class F secured income interest. It's actually, the defined term is actually Class F secured income additional interest. There is no defined term, additional Class F secured income interest. The additional is in the wrong place. That's a sort of infelicity which we're used to, and we obviously know what we're talking about. So I wouldn't want it thought that I'm suggesting that there are no errors in this document. Here's one which we spotted. It's not a big one, but there are errors, of course there are. So those are two submissions on Condition 6, the 6A2 and 6M. The other point I should just pick up... Sorry.
Under M then, on the previous point, it's the words, is it following payment in full of all amounts payable pursuant to the priorities of such payment date?
Yes.
Those are the critical words there.
Lord, yes.
I see. Thank you.
Now, can I, at this point, just pick up another submission made yesterday by my learned friend, where my learned friend was dealing with what he called the shape of the transaction. He referred, this is not actually a direct answer to the clause 6 point, condition 6 point, but I think it's the best point I can, best place to make this submission. The learned friend yesterday referred to condition 10C5, and that is not in the core bundle, I'm afraid, but it is in bundle 2 at page 401. B2, page 401. Just so that the court recollects the nature of the point, if we could start at page 400, the court will recall that my learned friend took the court to the acceleration provision, and we are in condition 10, which is all about events of default. It starts at 398.
In fact, I do have the other bundle. Oh. Very grateful to my God. So I now am on page 401.
I'm grateful, my lady. If my lady could just turn back to page 400 just for a moment. So we see that we are dealing with acceleration, as my learned friend showed the court yesterday. And he then showed the court Roman 5 on page 401. And this was part of his submission as to when condition 3 and when condition 11 apply. And he noted that if an event of default occurs, but the trustee doesn't think that there's going to be enough to pay off all the sums which are due under condition 11, it directs the collateral manager to keep the assets and to continue to apply condition 3. And learned friend's point was, well, isn't it odd that the ICMF, the collateral manager, would get an ICMF in those circumstances, but not, he says, in the case of an optional redemption under 7b? The short answer is, it's not odd at all. In the scenario that we're looking at under clause Roman 5, the deal is still running. The condition 11 waterfall applies when there is enforcement or an optional redemption, which bring the deal to an end early. So, insofar as learned friend was relying on clause 5 to make an additional point, with respect, it's not a good point, because there's no oddity here. You're in condition 3 territory because the deal is still a running deal. So those are my submissions on the 2 new points raised by my learned friend in this court. I think the only 2 other points I have to deal with are, I think quickly, my submissions on the nature of optional redemption provision, and then insofar as the court finds it helpful, I just would like to show the court those 2 sheets, just so the court has, I hope, a clear grasp of how this deal worked and was meant to work. I'm certainly not going to be making submissions based on what actually happened. Can I first, therefore, turn to the nature of the optional redemption provision? And these are the submissions under condition 7, which starts at page 169 in the core bundle. And the court has my main submission here. My main submission here is that when you look at the machinery which you need to operate in order to have an optional redemption, and that machinery starts at right at the bottom of 170 in Roman 2 and goes over to 171. My learned friend took the court through it. My submission is that you need to know what the ICMF is going to be in order to know what the RTA, the redemption threshold amount, is.
You need to know what the IMCF will be.
In order to know what the redemption threshold amount is. Because you can only redeem if the collateral manager provides evidence to the issuer and the trustee that they're going to be able to sell the assets to produce enough to hit that redemption threshold amount, to pay everybody off. That's a condition to the optional redemption. And if I am correct that the ICMF in the condition 11 waterfall is accrued and unpaid ICMF, i.e. it's a sum which should have been paid on previous dates and has not been paid, then of course there's no problem, because that is a fixed and known figure. But if the ICMF is only going to be generated as a result of operating the waterfall, it becomes, we would submit, commercially impossible to be sure that you're going to be able to meet an RTA. I accept there could be circumstances where you know the assets are so valuable, you're always going to overtop it. But the way this works is that you have to have an actual certificate, a sign-off for the RTA.
I know that, but I wonder how far... Look, that submission obviously has a certain attractiveness in a general sense, but I'm just querying how much weight one attributes in reality, because as this case has shown, you may underestimate the value of the assets. They may be sold for more than you thought they would. There may be some hidden expenses you hadn't anticipated. I mean, there may be all sorts of contingencies which may occur. You may be aware that these things may happen, but you've got to fix a figure. So, it's not as though everything else apart from this is going to be dead certain, because it's not.
I hope I'm putting this point realistically. I'm not saying that, so to speak, if I'm wrong on all the words, this is how I win. I can't. I'm not putting it that way.
But on the 2 points, really. One in the sense is that is your point about you have to know what the figure is, because you can't have you can't have some sort of guesstimate, which may or may not be right. But the other point is that given that this is an exercise that has to be conducted at least 15 days before the redemption date, if you're looking at what's actually accrued and unpaid at that time, you can't include, by definition, something that hasn't yet, where the relevant ICMF, if Mr. Railton were right, doesn't actually accrue until 15 days' time.
Yes,
What he's seeking is an ICMF that you calculate at the redemption date. But as at 15 days prior, you can't say of that, well, it's accrued and unpaid.
yes. I mean,
It's a matter of language.
I'm not going to charge my learned friend a brief fee for making a point which he would want to make. But in fairness to my learned friend, it may be said that if my lord, the Master of the Rolls' point is right as to estimation, it may be said that it would deal with that point as well. So I don't want to put this point too high, but certainly the way I put it is this, that the machinery in condition 7 is absolutely consistent with all the figures being either fixed or capable of being ascertained in a very straightforward manner. So, for example, when the learned friend says, well, there are administrative expenses, how much are they going to be? Well, that's true, but the point is this, none of the other amounts, and this may be where my Lord Justice Flaux was going, none of the other amounts in the Condition 11 waterfall, from A to U, depends on the value of the assets to be sold, or amounts which are to be paid later in the waterfall. To put that point another way, they all arise independently of any sums which are payable to the Class F Noteholders. So, although
They're all independently ascertainable, you say?
yes, independently of any sums which are payable to the Class F Noteholders. So
Yeah.
you may need to knock on the door of your lawyers and say, can't remember if it was White or Case or somebody else, what's on the clock at the moment? And they might say to you, it's about £50,000. We just need to check, but it's around £50,000.
It could be 60.
It could be 60. First of all, they will come back to you, and they can come back to you with a precise figure, point 1, in 15 business days. And secondly, what the value of the assets are worth and what the Class F Noteholders are going to get paid has got nothing to do with what White and Case have got on the clock. So the fact that there may be a measure of estimation, as my learned friend said, in some of the other figures, it's a qualitatively different sort of estimation. I hear, with respect, my Lord, the Master of the Rolls' point. I'm not putting this point too high, but
But the Chancellor didn't regard this as a killer point.
no, he didn't. He didn't. I think he saw it as a buttress,
Yeah.
whether a flying buttress or some other buttress, but certainly a buttress to my argument.
Yeah.
The other point which I make is this, and I make this with a little hesitation, but I did make the point before the Chancellor, and the evidential gap has not been filled, so I make it again. If one goes to Mr. Falconer's witness statement, and I'm just going to give the court the reference given the time, it's the first witness statement, the one we just looked at bundle C, tab 2. And we look at paragraphs 36 and 37, around there, where he talks about what happened when the portfolio was sold. There is no evidence that any of this machinery was in fact put into play. There is no evidence that there was any certificate. There was no evidence that there was evidence in a form satisfactory to the trustee that the collateral manager has entered into binding agreements. There was none of that. Now, the relevance of that is this. We highlighted this point, i.e. this absence of evidence, before the hearing, before the Chancellor, and the evidential gap was not filled. We ran the point in front of the Chancellor. It wasn't filled. It hasn't been filled until now. Now, I'm not going to fall into the trap of saying, because there's no evidence that they followed the machinery, that shows I'm right, because the machinery could not have been followed. I'm not making that point. But I am saying it is instructive that they didn't follow the machinery in this case. And it's instructive because on our case, it would have been extraordinarily difficult, if not impossible, for them to follow the machinery because of the points I've been making about estimation. So I do rely on that evidential gap in that limited sense. So those are my main submissions on condition 7. I just need to respond to one further point from a learned friend on condition 7, which was...
Well, I'm not...
sorry.
Sorry, I understand again. I see what you're saying there, but that seems to be mixing fact and principle in a curious way. I mean, you can say, how would they do it? But really you're saying... are you saying, in fact, they didn't do it?
Well, there's no... He gives evidence as to what they did. He doesn't give evidence that they did any of this. We've raised this point now on 3 separate occasions, and the evidential gap has not been filled. So I think I'm entitled to invite the court to proceed on the basis they didn't do it. Now, I accept the fact that they didn't do it doesn't mean it could not be done. I accept that. But the fact that they didn't do it in circumstances where, on my case, it will be extremely difficult for it to be done, in my respectful submission, does have some force. It's not going to get me home. But my case is that the condition 7 machinery doesn't really work properly on my learned friend's case. The fact that they didn't...
Why? I don't know why. Look, let's not take up more time than
Yes.
is necessary. But I remain slightly sceptical about the use of the adjective impossible or anything like that. I mean, why is it so difficult? You know, you anticipated what the sale price is going to be. As you say, all those other factors going down to it is you before you. I don't know. Don't require any assessment of what the ultimate value is going to be. You know, you make an assessment. And moreover, there's a point that the Chancellor seems to have accepted, and I hope I'm right about this. He seems to accept that although you can't have a second redemption date, what you do is where what you've anticipated has not in fact happened because of sales prices or whatever, you retrospectively adjust your figures.
Yes, but
So if he's right about that, there's already a kind of a mechanism that's already inserted there for adjusting.
I respectfully accept that. But my submission is that when you look at the condition 7, it's not that you take an estimate of what the portfolio is worth. You cannot operate an optional redemption unless you know and you have hard evidence in the form of binding agreements with counterparties of sufficient creditworthiness that you will sell the assets for an amount which is at least equal to the RTA. If you haven't got that, you can't do it. And my submission is simply that, on this point, the fact, well, 2 submissions really. First of all, the fact that you have that machinery is far more supportive of my case and my learned friend's case. The fact that the machinery wasn't operated, ditto. I'm not sure it goes much further than that, and it's not going to get any better if I say it again. Can I turn to, however, a point which I should respond to, which is my learned friend tried yesterday to turn this point on its head and to try to make this point a point in his favour. And as we understand the point, I'll give my lords the reference, my lady, the reference to the transcript, but I won't read it out. It's at page 15 of yesterday's...
1.5.
Yes,
Thank you.
Yesterday's transcript.
we haven't got the transcript.
We will make
I hope
sure
we're going to get it.
we will make sure the court We'll make sure the court gets it.
Oh, it's on the bench. I'm so sorry. I see. Yes, thank you. Okay. Page 15, should we look that up?
He took the court to clause 7BC, and I'm taking it now because it's on the previous page, and the page we were looking to. It's on page 170 of the core bundle. And to remind ourselves what this point is, it's that these are the various optional redemptions, and he took the court through them, and he noted that C, redemption at the option of the collateral manager, takes you to the condition 3 waterfall rather than the condition 11 waterfall.
So we're looking at
7BC. 7B1C, learn French right.
7B1C.
1C, page 170.
Yes, thank you.
And when he showed the court that this optional redemption takes us to condition 3, my Lord the Master of the Rolls asked what would be the commercial reason why you go to 3 and not to 11. Now, learned friend, I don't
That's
think...
because, the reason I mentioned that was because that's definitely, that's been clearly identified, because if you take B, for example, or B, they are specifically related to condition 7.
Precisely.
So there's a definite choice to be made there.
Precisely. The way my Lord put it yesterday was that the drafter was, quotes, very particular.
Yes.
Now, my learned friend, I don't think gave my Lord an answer, but let me try to answer my Lord's question as to why, commercially, it's condition 3 here. When you look at what C is actually doing, C is an optional redemption at the option of the collateral manager when you're still in the reinvestment period, and the court is, I think, familiar with what that is. But the collateral manager, if we look at it, let's pick it up if we can, 4 lines down, and the 2/3 of the way across the line there's an if. If at any time during the reinvestment period the collateral manager by notice certifies that it's been unable to identify additional collateral debt securities that are deemed appropriate by the collateral manager, which meet the eligibility criteria or the reinvestment criteria in sufficient amounts to permit the investment or reinvestment or all or a portion of the funds that are to be invested. In other words, the collateral manager's got money, he should be investing them, he can't find stuff that's eligible to invest in, if I can put it in that way. What then happens, if we carry on reading, on the first payment date, following the due period in which any such notice is given, funds on deposit in the principal, actually there's an in there missing, in the principal collection account, representing principal proceeds which cannot be reinvested in additional collateral debt securities, will be applied in accordance with paragraph R of, square brackets, condition 3, principal waterfall. That's what condition 3C2 is. So that makes, in my respectful submission, absolute sense. The transaction is ongoing, it's not being brought to an end. There's monies which should be invested in new securities. The collateral manager can't find securities of the appropriate criteria. The monies are sitting in the account. They're paid through the condition 3 principal waterfall. In my respectful submission, that's the answer to my Lord's question. I think the very final point I should make on condition 7 is to go back to a point...
I see that, but this is a redemption. Hang on, there is a redemption here.
Yes, but
slightly lost track of it.
It's not. It's a partial redemption. It's not going. It's not. The whole transaction hasn't been brought to an end.
Right. So it's. Can I just read the rest of this? Actually, I haven't read this properly. What is the nature of this? What is the nature of this redemption?
So what's happened is, let's say you've got, just to make up some numbers, you've got 100 loans. During the reinvestment period, a number of them mature. It's a reinvestment period, so you should be reinvesting. There are criteria which I wasn't going to take the court to as to what are eligible things to invest in. This posits that the collateral manager can't find enough of them. So it's got an amount of money which it should be reinvesting, but it can't. The transaction is not going to come to an end. This is only the money sitting in the principal proceeds account. What do you do with those principal proceeds, which you, in the ideal world, you should be reinvesting? You pay them through the principal waterfall in condition 3. Why is it condition 3, not condition 11? Because the transaction is ongoing. You're only dealing with this amount of money, the amount of money which otherwise you should be reinvesting.
It describes it as a special redemption. It's actually a partial redemption. It's partial redemption.
Exactly, it's partial redemption. It's partial in both senses. It's partial in the sense that it's part of the assets which underlie all these notes, and because of that, it'll be partial in the sense that when you start running it through the principal proceeds waterfall, condition 3 principal, you'll start at the top, and how far you get down will depend on how much you're talking about.
Yeah.
So maybe, for example,
So redemption. I'm just thinking. I'm looking at it and comparing it with V of the condition 11 waterfall, which is the redemption of the Class F secured income notes. I mean, that's the kind of gold star of redemption.
yes,
I'm not trying to go back on your description of the way these operate, but it's notionally a repayment, notionally, for this purposes, a repayment of your equity.
so, yeah, but this wouldn't get to Class F. This is being run through the condition 3 principal waterfall. So you'll start with the senior notes and the B's and the C's.
I see. So it's slightly. I think what may be odd here, if one stands back from it, is the description of it as a redemption at all. Maybe it shouldn't be in this section logically at all. It should be somewhere else.
Well,
It's not really a redemption, to be honest.
I mean,
It's not really a redemption.
well,
Yeah.
you're paying off the principal balance of some of the notes. That's what you're doing.
So,
Yes.
But if you look at R of the principal waterfall, condition 3 waterfall on page 154,
Yes.
you get a bit more of a sense of it as a partial redemption, don't you?
Yes.
And the whole load of these
Exactly.
I don't know what you
yes,
call them,
yes.
steps in the waterfall to do with the reinvestment.
It's the redemption. It's the partial redemption of whatever the notes are in the order of priority.
Well, the principal on those notes. And indeed, if we look, as my Lord the Master Rolls has raised the point, if we go back to 7b Roman 1a, which is, so to speak, our redemption, and we just glance through that first paragraph, you can see that all the people hired to us, the senior notes are effectively the A's. B, C, blah, 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 about 6 lines down, shall be redeemed, and then redeemed. Ditto in B, redeemed. C, I accept it says redemption at the option of the collateral manager, but it starts off principal on the note shall be paid. You're paying principal. It may be one of those cases where you need to look, so to speak, the heading is the deceptive bit.
But why? Sorry, then I'm going to go. It's true that the transaction is still continuing, and therefore you've chosen 3. But you could. Would it have made any difference in practical terms if you had in fact chosen the condition 11 waterfall? Because that also provides, does it not, for redemption of the various notes at various points in it, not right at the top.
Yes, but the
Why?
but the order's different, and the 11 waterfall is run when the transaction is brought to an end early.
No, I appreciate that.
Yeah, I mean, the commercial effect in certain circumstances might be similar. It might be similar, but it could be very different because, for example, in 11, as we saw yesterday, if you ran it through 11, if we turn back to 175,
Yeah.
let's forget all the fees for the moment. H, the first thing you do, first of all you pay, where are the, yes, F. The first thing you do at F1 is pay interest due and payable on the senior notes. Well, that's materially different for a start from what you do in the condition 3 principal waterfall, where you're looking at the principal amount, and then ditto with the B's at H and I. So there will be necessarily material differences between running the condition 3 and the condition 11 waterfall.
Right. So you've explained the answer. You've explained the answer to C.
Yes.
Thank you.
And
do you get anything? What do you get out of that, if anything?
I get out of it, my lord, the point which my lord put to my learned friend, which is the drafter here is very particular. In other words, there is a commercial reason.
The commercial reason is it's unlike under a condition 11 situation, you're not actually dealing with the complete unravelling of the entire transaction.
Yes, or bringing it to an end, perhaps.
An optional redemption by the note holder
Does bring it
brings
to
the
an end.
whole transaction to an end.
Exactly. And
This
sorry.
provision only brings that part of it, which relates to the principal sitting in the account that the collateral manager has not managed to find anything else to buy.
Yes.
Yeah, I mean that's the reason why. But the point you're relying in terms of argument
Exactly.
is that the draft has actually you submit that the draft has in every case very carefully applied the mind to which of these provisions it's going to apply.
Precisely.
That's
Precisely.
the point, yeah.
Precisely. Now, the last point made by my Lord Justice Flaux is, if I may say, a useful springboard for the point I want to make, and this is the last point on condition 7, responding to a point my learned friend made yesterday. And I think this was a new point. I don't think this was in the written argument. As I understand the point, it was this. He said the way condition 7 works is that you have to put in place agreements with suitable counterparties to sell enough of the loans to generate funds in an amount equal to the redemption threshold amount. He said, what happens if, let's say, the redemption threshold amount is 100? What happens if you enter into agreements, but you can only enter agreements for 85? He said, well, obviously, and he's right, you can't have a redemption then, because the condition is not satisfied. But he went on to say, those agreements which you've entered into for 85 would operate. The monies that come in would go through the condition 3 waterfall. And he says, even on my case, the Napier Parts case, he would get an ICMF. So isn't it odd, he says, that in cases where he, so to speak, fails to hit the RTA, he could get an ICMF. But in circumstances on my case where he does, and the condition 11 waterfall operates, he doesn't get the ICMF. Yes. As I understand it, that was the point.
Yes.
The short answer to it is that it is inconceivable that this is the way it works. It's simply inconceivable that the way it works is that the Class F Noteholders say to the Collateral Manager, we want to exercise an optional redemption to bring the whole transaction to an end. The machinery provides that the only way this works is if the Collateral Manager enters into transactions sufficient to generate the RTA. But the Collateral Manager can turn around and say, well, I'm sorry guys, although I tried to generate 100 to give you your optional redemption, in fact I've only generated 99, but I've sold them anyway. I mean, the way this works is that all of these agreements are plainly conditional on the optional redemption taking place. And the scenario, I think it was a new point made yesterday, this scenario where we posit a situation where we vote for an optional redemption, the Collateral Manager, and remember the Collateral Manager has actually to provide evidence that he will sell for 100, That's the machinery point. But then it turns out he's only able to sell for 95, still goes ahead and sells at 95. What would happen in those circumstances is the transactions don't happen.
It's all or nothing.
It's all or nothing. Our instruction is for an optional redemption. Our instruction is not an optional redemption or the best you can do in the circumstances. So that point, therefore, which posited...
Sorry, I'm just trying to remember. There are a couple of points here. I think the overall essence of your point is it is simply unrealistic to take as an example a case where there's an optional redemption where you don't actually sell for the full amount.
Yes.
That's the first point. But just to help me on this, my recollection is there are two distinct stages to a redemption. One is the issuing of a redemption notice,
Yes.
and then there's this enforcement. There's perhaps a notice, and then the enforcement aspect of it. There are two things that have to be done. There has to be an enforcement notice. Sorry, there has to be an enforcement notice. I think, is that right?
It's not quite enforcement. There's a notice. Can I just show my lord? It's on my lord the words on the page. It's 171. Top of the page is a direction or consent from basically the Class F.
Sorry, 171.
171, top of the page. The first thing is we direct...
Receipt of.
Yeah, receipt of a direction or consent from us. That's the first thing. The second thing that happens, 5 lines down, is that the collateral administrator shall, not less than 15 days prior to the scheduled redemption date, calculate the RTA. That's the second thing. So we issue the notice, the collateral administrator calculates the RTA, and then, and the RTA of course is all the amounts which need to be paid prior to us, and then you go to the second paragraph on this page, which provides that the note shall not be optionally redeemed unless the collateral manager shall have furnished to the trustee evidence in a form satisfactory to the trustee that the collateral manager has entered into a binding agreement or agreements with a credit-worthy financial institution to purchase for cash an amount equal to the RTA.
So that's the
That's
point.
the point.
So that's the reason. The reason it doesn't go ahead is because that's I think was in the back of my mind. So that's an essential prerequisite to the thing taking place at all.
Exactly. And so the learned friend scenario is where we issue a notice and the RTA is calculated at 100. The collateral manager goes out there and enters into agreements and he can only get to 85. So he comes to the trustee and says, here's my evidence. And the trustee says, well, that's no good. That only amounts to 85. You need 100. Oh, says the collateral manager on the learned friends scenario, well, that's tough because I'm now selling that 85 anyway.
So the point is, I think the point is, one, it's unrealistic, but more to the point, it's not possible.
It isn't possible.
It's not legally possible under the contract.
Okay, so my lord, those are my points on the documents, and perhaps I can literally I will try to keep this to 10 minutes, just to show my lords a couple of points, if I may, just on, so to speak, how the transaction worked. And I'm going to try to do this as dispassionately as I can. And my lords may find this helpful when my lords come to write their judgment. There are two sheets in bundle C6, which might be helpful. And C6. And I hope they illustrate a number of things which we've been looking at. The relevant pages are 189 and 190. And I should say, I have these in A3 if the court would find it helpful to work off.
That probably would be quite helpful, actually.
Yeah.
Perhaps you
And
can make sure a couple are given to Lady Justice Asplin's clerk.
Yes. Should we give you? Why don't I give you two more? And there's a spare. Now, if I could invite the court to start at 190. Well, actually, let's start at 189. Let's start at 189, and I'll explain what 189 is. 189 is what actually happened. And what you can see in 189 is on the left-hand side, you've got the dates. You've then got the net portfolio collateral balance, i.e. what the portfolio is, quotes, worth. The next column, in red, is the haircut due to defaults and CCC assets. I'll come back to that. You've then got what's called the Class E over-collateralisation test level, and at T1 and T2 you'll see that there are two columns of pass and fail. The court will recall that there are two over-collateralisation tests which have to be met. You'll see the threshold in the first is 105.9 and the second is 104.4. And at a very general level, as we set out in writing in our skeleton, if you fail the OC tests, securities income is diverted to the principal note holders, and sometimes you have to sell the securities as well. Sorry, securities which have defaulted, you have to try to buy other securities to replace them with money that otherwise would have gone to the note holders. So, if we go to the right-hand column, where it says excess income received by Class F notes. The excess income, this is what we've been calling interest through the Class Condition 3 interest waterfall, which is in excess of what's needed to pay everybody else off in the Class 3 interest waterfall. You'll see that when the transaction starts off, it starts throwing off excess income, which, having gone through the interest waterfall, comes down to the Class F note holders. And there's about 8 quarters when that happens. Then, my lords and my lady will see a gap in that penultimate column, looking at from the right-hand side. Yeah. And if one looks to the left, you'll see that is when the OC tests start to be failed. So when the OC tests are failed, because income has to be diverted to more senior notes and to purchase other assets to make good the deterioration in the underlying portfolio, who does it hit first? Well, it hits the people at the bottom of the pile, the Class F note holders. And indeed, to make the point I mentioned yesterday, because their position is 10 times leveraged, if the actual value of the portfolio was to deteriorate by 10%, that wipes out their equity.
Yeah. Mm-hmm. Yeah.
So what one can see is that the effect of that, there's a direct correlation, if I can put it this way, between failing the OC tests in the middle of the page and the gap in what the Class F note holders get on the right-hand side. The last column is the IRR. And the court will see that the IRR doesn't even begin to be positive until you get to, I think I'm reading across right, 1 November 2014. Once you get to 1 November 2014, if you add up everything in column which has a little a on the top, that gets to basically the IRR of 0. Then you start to get a positive IRR. And the figure of 7.58, which has been mentioned, I think, by both of us in this case, is that figure in the bottom right-hand corner. In other words, when it came to the optional redemption, at that point, the IRR was still 7.58. So to speak, this is, so to speak, what happened. On page 190, to illustrate the effect of all of this, what has been set out at 190 is what, so to speak, would have happened, or perhaps I should say might have happened. I don't mean would in the sense of necessarily would. If there'd been no defaults, there hadn't been defaults. Now, I accept that this is hypothetical. It says that in the top of the page, because there are always defaults. But it's just trying to give an impression of how this works. And we see a number of things. First of all, you'll see that looking at the pre-penultimate column from the right-hand side, the distribution to the F note holders, and of course the first few amounts will be the same as on the previous page, are much higher. And the effect is that you hit that 10% IRR in August 2013 if the over-collateralisation tests had not been failed. The second thing you notice, and this goes to my learned friend's point, that we might want somehow to game it, to game the transaction, to deny the collateral manager an ICMF. What we see is that if you run the numbers, I think I made this point earlier, if you look at that point from the 1st of August 2013 and you run it forward, that very last column, which ends up at 36.6 million, that's everything that the Class F note holders have got after the 10% IRR has been reached. And the middle column is what the ICMF would have been, 13 million. In other words, once you hit the 10% IRR, if the portfolio is functioning, it makes absolutely no sense for the Class F note holders to bring it to an end, because they're still quids in, if I can put it that way, even paying ICMF. Yeah. It's in their interest to keep it up and running, because whatever they're paying by way of ICMF, they're actually making more money.
So they pay, on this hypothesis, they end up paying out 13 million in ICMF out of effectively a total of 49.5 million, but they pocket the 36.5 million.
Exactly, that's right. Exactly, the 36 million is net, if that's the way my lord is putting it. Yes, exactly. So, but of course, what actually happened is, going back to 189, is that between the 3rd of August 2009 and the 3rd of May 2011, all excess income is diverted, and we see that in the middle set of columns. It's headed diversion of payments away from Class F notes, and you'll see that there's a diversion to purchase additional, that's misspelled, portfolio securities, a diversion to repay senior debt, and then the total diversion. And the effect of those diversions is that, of course, you don't hit the IRR at all, the 10% IRR at all. Now, I hope that's helpful to give the court a shape of it. There is perhaps something of a jury point here, which is, learned friend says, well, this was in one of the top 20% of transactions for the relevant period. Well, it might have been, but the relevant period is a pretty poor period because it included the financial crisis. And what we do see from those documents, I hope...
He could rightfully say, well, then it goes to show how very well they did.
Precisely. That's why I highlight it as a jury point, precisely. But I hope that's helpful. I try to do that in a neutral way as possible before allowing myself that jury point. I hope those are helpful so the court sees the nature of the structure, and the importance of two things. First of all, the over-collateralisation test and the diversions, and secondly, the point that if you do hit the 10% IRR with a functioning portfolio, as a Class F note holder, it's in your interest to keep it running. So, my lords, unless I can assist the court further, and it's bang on 12 o'clock, those are my submissions.
Does Lady Justice Asplin have any questions?
No, thank you.
Thank you very much indeed. Mr. Rill. We have to finish at 1 o'clock.
I'm sorry, my lord.
You have to finish at 1 o'clock.
Oh, certainly. I don't anticipate being that long. I'm not in any way disheartened by my lord thinking I might.
It wasn't a point to character.
My lord, my lady, there are a number of points to respond to, but perhaps I could start just by saying this. The literal approach to construction only really works if the language used is genuinely clear, if it's mutually consistent with other provisions in the documentation, and if it provides across the documentation as a whole a coherent, consistent and commercially plausible approach to the issue the court is considering. And that is not in our submission this case, because as is apparent from Mr. Wolfson's submissions, at each stage the literalist has to ignore obvious inconsistencies and ambiguities in the document, and indeed has to distort the language used to make the construction contended for work, while ignoring, in our submission, stage by stage, the commerciality of the result produced. And we can show this just by touching on the two big and now freestanding points relied upon by Napier. The first being the contention that so-called new ICMF is only paid on a payment date which engages the condition 3 priorities of payment, and is not paid on an optional redemption because such an optional redemption engages the condition 11 priorities. And as to this, Mr. Wolfson in our submission has simply not engaged with or answered the inconsistencies which his construction gives rise to. And the main ones are, as you will recall from yesterday, and taking them very shortly, first it's the entitlement that you see in clause 14 and the ICMF definition to payment of ICMF on each payment date, which includes the redemption date. Then there's the unqualified reference in clause 14 to the priorities of payment, which necessarily include condition 11. And then there's the fact that it is accepted that deferred ICMF is payable on an optional redemption date, and therefore is payable in accordance with condition 11, meaning that the definition must be read to include payments in accordance with condition 11. Now, these inconsistencies in our submission have simply not been dealt with by Mr. Wolfson, and nor has he grappled with how the definition should be read or rewritten to accommodate his exclusion of an optional redemption date for new ICMF, but not for deferred ICMF. And still less in our submission has he explained why, if the parties really intended that there should be no new ICMF payable on an optional redemption date, why they didn't actually say so. Using language, for example, which we see elsewhere in the documentation, and just to remind you of one place where it appears, at bundle B2, page 367, and this is page 148 of the core. This wording I showed you yesterday, right at the top of the page, under subparagraph C, this is condition 3, priorities of payment, the collateral administrator shall, on behalf of the issue, on each payment date, and here come the relevant words, save for any redemption date applicable to the redemption of the notes pursuant to condition 7b. In other words, where the draftsman has thought that it's appropriate to have a carve-out from the reference to each payment date, which, as we've seen through its definitions, includes each redemption date, it is said so. And you'll recall similar wording appears in the priorities of payment at bundle B3, page 715, the definition of priorities of payment, and it's bundle A, page 144. Again, I'm so sorry, my lady.
Thank you.
144.
44. It's simply priorities of payment. Just another place where this technique is used by the draftsman. A starts save in respect of any redemption of the notes pursuant to condition 7b. So it is not beyond the wit of the draftsman, had this been the intention, to have a qualification in the payment date provisions, either in clause 14 or indeed in the definition of ICMF, that simply said something like, save for any redemption date applicable to the redemption of the notes pursuant to condition 7b. Now, of course, Mr. Wolfson would then need to have certain carve-outs for deferred ICMF, as he accepts and indeed relies on the fact that that's payable. But my lord and my lady, when one's looking at the language, it is a legitimate question to ask, well, if Mr. Wolfson is right, why didn't the draftsman say so, instead of using what on any view is convoluted language? And in our submission, if you add the fact that the economically identical fee, the CMTA, which I'll come back to separately in a short time, has no similar references to condition 3 in the provision that establishes it, and that the draftsman has form for referring to the condition 3 waterfall where it is unnecessary and patently not intended as a restriction. And that is a reference to condition 6A2 on page 385 of bundle A, which, bundle B2, page 162 of bundle A, which Mr. Wolfson showed you earlier. And just remembering, as Mr. Wolfson said, it's quite clear from the language that it's intended that this additional secured income interest is going to be payable on a redemption. That was my point yesterday. But the point is that the draftsman, again, for whatever reason, has deliberately referred to it being payable in accordance with condition C. Cannot be meant. It's not intended as a restriction, in the same way as it's not intended as a restriction in relation to the ICMF definition. And it is the deliberate use of language, technique one often sees in documents of this sort, put in where it's unnecessary, strictly unnecessary. It's not a restriction. And we suggest that if you take the inconsistencies I referred to a moment ago and referred to in more detail yesterday, you add in the fact of the CMTA, the techniques that we see elsewhere in the documentation, particularly in clause 6A2 that we've just looked at. That is in our submission more than enough to show, before you even get to considering the commerciality of the judge's construction and Napier's submissions, that the reference to condition 3 in the ICMF definition is unnecessary. It is not intended as a restriction. And what in fact governs whether the fee is payable is the Collateral Management Agreement and, of course, the CSI and the SIT thresholds. Now, I should address here briefly Mr. Wolfson's contention that the CMTA is not economically similar to the ICMF. And the only reason I think that he relied on for this was because he said there was no provision for what may be a valuable right to defer CMTA, which he said was in contrast to the position with the ICMF. Now, my lords, my ladies, we do not accept that that is right on the terms of the documents. There is nothing in the CMTA provisions, and to remind you that's clause 18.8 of the Collateral Management Agreement, there's nothing there which say the amount payable on a particular payment date is reduced by sums not paid on previous payment dates. But in any event, the waterfalls clearly refer in condition 3 and condition 11 to the payment of any CMTA. And perhaps I should just show that by reference to condition 3, or the interest waterfall. It doesn't really matter.
You're getting quite fascinated. So I just want to pick this point up. You're saying that there's nothing in the provisions relating to CMTA which says that you can't take over unpaid CMTA. Is that the point you're making?
Well, my lord, perhaps I should have shown you, and I'm sorry, I'm endeavouring to move quite quickly, but perhaps I should show my lord clause 18.8 again. It's bundle B3, page 589, or core, page 185. And it's the subparagraph B at the bottom of the page. And the short point there is that there's nothing in those provisions that say an amount payable on a particular payment date is reduced by sums not paid on previous payment dates. Now, obviously, if sums were paid, you can't get them twice, but what you're looking at is 20% of the cumulative subordinated income in excess of the principal amount. That's payable, assuming, of course, that the SIT is reached. And that is an obligation that arises. It's an ongoing obligation to pay it. And it's a very short point.
But 18.8.3 provides that if you haven't reached the threshold, let's say the SIT, then you don't pay.
Oh, indeed. But this is premised on the threshold having been reached. Absolutely.
So, and there is force in his point that unlike where you can defer because of where the ICMF falls into in the condition 3 waterfalls as you're going along, as it were. You don't actually have enough income, if I can put it in loose terms, to generate an ICM to actually pay it.
Yes.
But you defer it.
Well, I follow that, my lord, but that arises, as Mr. Wolfson has said, because within the interest, the 3C interest waterfall, you have that 50% cap on the ICMF.
Yeah, but I follow the point. But you still get deferred ICMF, as it were, that's then put into store.
Yes.
That then comes out of store at a later stage.
Well, indeed, I accept that. In relation to ICMF, you can see why there's reference to deferred, and indeed the Collateral Management Agreement envisages deferred elements, primarily, of course, in relation to base collateral management.
Yeah, I think that's really all he's saying.
Yes.
That you don't get,
And
on any particular benefit, if you don't reach the threshold, you don't get anything, and you don't get some accrued right to receive something later.
oh, I'm sorry, then I might have simply misunderstood the point. I thought that what he was saying,
That's all he was saying.
I thought he was making a similar point to ICMF. The point being that an entitlement to CMTA may arise, but not be discharged because they're inadequate funds, in which case that becomes deferred and is paid on the next quarter payment date.
Well, I don't think there's anything in the provisions which would justify that construction.
Oh.
I think that's all he was saying.
But we may be violently disagreeing about, or violently agreeing.
Well, certainly, I'd understood Mr. Wolfson's point here to be that one of the reasons why these are commercially very, very different, he says, very different, was because in one case, if there are insufficient funds, the payment's deferred and taken later on. There's no such provision here. Indeed, there's an express provision that that's the end of it.
Yes. Well,
that's commercially very, very different.
Well, save that. While we would accept that there's no provision that says you defer it, that doesn't deal with the question as to what is actually payable on the relevant payment date. that is governed by clause 18.82b. And it's a short point,
Well,
but
you're
that,
entitled to say, unlike with ICMF, there isn't a cap, so that you in effect have to defer part of your CMTA because there isn't a cap. So if you reach the income, if you reach the threshold, you're entitled to be paid,
yes, indeed.
and the note holders cannot say, oh, well, there's a 50% cap or whatever it is.
Indeed.
So some of this becomes deferred. So I mean, that's a perfectly valid point. I follow that.
Indeed, and that's in relation to the language here, but it's also, we say, supported by, or when it may be a slightly different point, but the language in the waterfalls, which use different language, which refers to any collateral manager termination amount. It doesn't use the language of accrued and unpaid. It uses different language, but language which is clearly more general.
So, I'm sorry. Right, I'm getting slightly lost on this point. I'm not sure how important it is, but I'm getting slightly lost on it. I thought you were saying, the point you were addressing was what is said to be a significant difference in the commercial nature of these two items, the incentive fee on the one hand and the CMT on the other hand, and you were saying you didn't accept that.
Yes, indeed.
And then 2 points, one point I picked up from that so far, but I may have missed on the logic of this or the analysis, is you're saying, well, it's 18.82b that tells you what's payable on any
Yes.
particular payment date.
Yes.
And so how does that answer the point?
Simply because you would clearly, if say on payment date 1, a sum of 100 is due by way of CMTA, and is paid, you would not be seeking that sum again on payment date 2. But if when you get to payment date 2, that hasn't been paid, the calculation in relation to what is payable of 20% of the cumulative subordinated income doesn't require a reduction for what should have been paid but hasn't been paid on the previous date. It's that small a point. Just how the mechanism works. But the second, possibly alternative but also additional, is the description of the payment of the CMTA in the waterfalls, which is consistently in terms of any. But I won't spend, unless my lords would, and my lady would like me to, I won't spend longer on the point, not only because it's slightly disproportionate for the matter to which it goes to, because it is, in our submission, in any event, irrelevant. Because the relevant question that we're looking at is new CMTA.
New CMTA or new ICMF?
Well, it's new ICMF to be compared to new CMTA. And on new, whether ICMF or CMTA, it is identical. It clearly is. And there's been no suggestion that there's any economic difference in the formula used.
So which formula is this?
This is the formula, again, starting, if my lord still has page B3589 or core bundle page 185, clause 18.82b, 20% of the CSI and the SIT threshold, of course. And there's been no suggestion that in relation to that there is any economic difference at all. And my Lord the Master of the Rolls, I think, has made a number of comments that, well, the structure of this fee and the fact that it's pitched economically identically to the ICMF would indicate that it's there, in part at least, as a disincentive to terminate the collateral manager without cause. And my lords, my lady, that may be the case. But if that is so, it doesn't affect the construction at all of how the fee works if it is engaged. And that is why the economic similarity as to how the draftsman has approached dealing with two things that are economically the same is, in our submission, so important. And so that's why we say that the supposed distinction does not, that was put forward by Mr. Wolfson, does not undermine the points made in respect to the CMTA and the difficulties which in our submission it presents for Napier.
Well, I'll have to look at the transcript, but I mean, I think it's only fair to say I haven't, and I'll have to think further about it, I haven't fully grasped your first point on this about what is due on the payment date. I mean, I take your point, I certainly take your point, which I understand, about the wording of 18.82b in terms of the similarity of the test. I see that. At the moment, I'm just not really seeing the point about why that somehow, why that provision in 18.82b somehow negates the point that's been made, for what it's worth, by Mr. Wilson, that a major difference is the absence of any provision for deferral.
Well,
I'm sorry, I'm being a bit slow on that, but I haven't fully grasped that.
my Lord, I think it's probably unnecessary to go back over the points.
I'll look at the
I've made the submissions, but the key point is that is talking about something over here when the relevant question for the purposes of the construction exercise is on new ICMF and the CMTA.
Well, CMTA is the threshold hit. There's no right in the note holder to say, oh, well, I'm going to defer 50% of it. He
No.
has to pay it.
Yes, indeed.
If he doesn't pay it, then presumably the collateral manager could sue him.
Yes.
He'd have an immediate cause of action for outstanding CMTA from that quarter, that payment day.
Yes, indeed. But the whole point is that when one refers to CMTA, it is shorthand for 20% of the cumulative subordinated income after the 10% IRR has been hit. When one's referring to ICMF, it is short.
I think what it comes to is, I think you're saying is, for the purposes of this appeal, Mr. Wilson's point of distinction between the two things is actually a red herring.
It's a red herring. Well, it's
I think
first
that's
of all
what it comes to.
wrong, but one doesn't need to determine whether it's right or wrong because it is, as my Lord says, a red herring.
Yes. That point I can understand. I'm not saying it's right. I'm saying I can at least understand the point.
And my Lords, my Lady, Mr. Wolfson's attempt to bolster the condition 3 argument by reference to the CSI definition is, in our submission similarly, and simply misplaced. And this turns, you'll remember, on the definition at B3, page 679, or page 139 of the core bundle. And Mr. Wolfson's first point here was that the reference to interest proceeds and principal proceeds in the definition were neutral. But in our submission, that simply cannot be so when they are defined terms which include the proceeds of disposal of the portfolio in the due period leading up to the optional redemption date, and which are to be distributed on the optional redemption date under condition 11. And you'll recall that I showed you yesterday that that was a position that one sees not only in the contractual documentation, but also in the prospectus at page 15. Now, Mr. Wolfson's second point was to say our transposing of the liabilities identified in the condition 3 waterfalls in the CSI definition doesn't work because the line was drawn in a different place in the condition 11 waterfall. And I'm sure, my Lords and my Lady, remember that argument. In other words, what he says is that the line in condition 3 is drawn before payments to the collateral manager, but the equivalent line in condition 11 is drawn after those payments.
Class F Noteholder.
And that is only right if there's a deployment of some smoke and mirrors. If you define the line drawn in condition 3 as everything before the first payment to the Class F noteholders. And perhaps I could just show this by, again, I would invite you to keep
Could you just very briefly go over your first point, your second point? What was your making a note on something? What was your first point on the CSI matter? References to condition 3 there.
my Lord, the first point was simply dealing with interest proceeds and principal proceeds. How Mr. Wolfson said they were neutral, and our submission is that he's simply wrong on that for the reasons I've identified.
And that's you rely upon the definitions of those two.
Well, it's the definitions plus feeding through how they are sums that are provided to be distributed on an optional redemption date. And as we've seen, that would be under condition 11.
Thank you.
But just in relation to this second point, as to drawing the line, perhaps if I could start at page 370 of bundle B2, core 151. 151, my lady.
B2.
B2, page 370. This is just the interest, condition 3, interest waterfall. As Mr. Wolfson correctly pointed out, the line is drawn here at FF. From the definition of cumulative subordinated income. And so after that, you get payments to the Class F noteholders.
Yes.
You also get payments to the collateral manager of the termination amount or the incentive fee. One sees the same than 3, but Z and following are payments to the Class F noteholders and the collateral manager. Now, the comparable line in condition 11 is before T, and one sees this at page 403 of bundle B2 or 176 of bundle A. One looks to see what are the liabilities that are comparable to those that we've seen in condition 3. In other words, what you're trying to do is to take out payments not only to the Class F noteholders, but the derivative payments from them that go to the collateral manager. And the line here is above T,
Above.
because you'll see T is
Yes, I see.
the collateral manager termination amount, then the incentive fee, then payments to the note. In other words, the logic is to exclude payments to the Class F noteholders and the derivative payments to the collateral manager. And so there is, in our submission, no difficulty at all when one goes back to the CSI definition of construing, as we say it should be done, the reference to the amounts payable in the CSI definition as a reference to the liabilities identified in the relevant paragraphs. They directly read across to condition 11, which deals with interest and principal proceeds in one waterfall, in, as you've seen, a closely tiered process. And that's to avoid the risk of some more junior notes being paid out earlier than the senior ones. And in this respect, Mr. Wolfson's criticism of paragraph 35 of our skeleton, where we said that, is simply not understood. We've never suggested that interest and principal is dealt with in one sub-paragraph for each class of the notes in condition 11. The point is that there is one waterfall in condition 11 dealing with both. And the alternative to our approach is to, in our submission, either ignore or to rewrite one or other, or indeed all, of the definitions of interest proceeds, principal proceeds, due period, or payment date.
Do you accept, I mean, he had a more fundamental point, as I understood his submissions, that if you look at the definition of CSI, your construction actually requires you to read in somehow that the deductions that are made under 1 and 2 in particular include the amounts payable under A to S of condition 11. And yet he says, well, that's not referred to anywhere.
My Lord, exactly. And that is the point, really, in relation to this. He said it's not referred to. Therefore, it's absurd, because there must be some deduction from interest proceeds and principal proceeds. We say, yes, it would be absurd if there's no deduction, because the whole purpose of this is to identify the subordinated income. In other words, the income that the Class F note holders actually receive. So faced with the problems that Mr. Wolfson has in respect of the definition of interest proceeds and principal proceeds, due period and payment date, what he says is, well, this must mean that it could only operate, ICF could only operate if condition 3 applies. But what we say is, no, that's just doing too much damage to the definitions of interest proceeds, principal proceeds, due period and payment date. And the way one should deal with it, applying standard principles of construction, is just to see that the reference to amounts payable under the relevant paragraphs of the condition 3 waterfall is identifying the liabilities in that waterfall.
I mean, his point is a more subtle one, I think, at least I think it is, that when you look at the definition of cumulative subordinated income together with the definition of ICMF, the interest proceeds and principal proceeds being referred to there, it all ties in with this operating under condition 3 and not operating under condition 11 at all, which is one of the reasons why he says when you get to condition 11, the accrued and unpaid ICMF is that which is at that point in time from the past accrued and unpaid, having been calculated in accordance with those definitions.
Well, indeed, my Lord, I follow that entirely. He relies on this to bolster his argument that when you look at the ICMF definition, those words in the first 4 lines referring to condition 3 aren't unnecessary words, aren't words, as we say, that just give rise to too many inconsistencies in the language, but are actually intended. And the point we make is, well, no, that can't be so, because look at the violence you have to do to the other language within the definition of cumulative subordinated income. You actually have to rewrite what interest proceeds and principal proceeds are, if he's right, because those are proceeds that are distributed on a redemption date under condition 11. And the way you square that circle, or maybe complete the circle, is simply by looking at the reference to amounts payable being references to the liabilities identified in those paragraphs. And you will have noticed that there's no suggestion by Mr. Wolfson that there is any different result if you look at the amounts or the liabilities identified in those paragraphs and the liabilities identified in the comparable paragraphs of condition 11. Not suggested there's any different result either in this case or in any other hypothetical case. And so if the liabilities above the payments to the Class F noteholders and the Collateral Manager are deducted, whether pursuant to the list in condition 3 or condition 11, it's the same result. And we would say that it is when one looks at those definitions, one looks at the difficulties which they give to the literalist construction. In our submission, what the court needs to identify is the most consistent, the most coherent, and indeed the most commercially sensible. And in circumstances where, one must remember this, the underlying purpose of the exercise in looking at the CSI is to look at the cumulative subordinated income to the Class F noteholders. And in those circumstances, it's quite obvious in our submission that all the constructional pointers are to including the actual income received by the Class F noteholders, and not something else? Now, in relation to condition 11, Mr. Wolfson made the further submission, which I hope I can deal with very briefly, that the waterfall doesn't work for new ICMF because the waterfall says ICMF is to be paid before the Class F Noteholders. And that's page 403 of Bundle B2 or Core 176. Now, I gave our answer to this yesterday, but it seems to me it simply hasn't been addressed by Mr. Wolfson, but it is actually fundamental to the operation of the waterfall. And in view of perhaps certain comments from the court, I think I do need to go back to it. And the simple point is that the waterfall represents a distribution of proceeds in accordance with the priorities set out in it. And it works on the basis that each euro flows through to where it's directed, with its destination changing as payments are made. So it is not a matter, when one looks at condition 11, of all the proceeds bypassing the collateral manager, because at the start of the distribution, the SIT threshold has not been met. That is not how it works. The proceeds bypass, or don't stop, maybe a better way of saying, at subcondition U until the SIT is reached. Then all future proceeds go 20% to the ICMF and 80% to the Class F Noteholders in conditions V and W. It's simply not a question of there being a one-off lump sum distribution down the waterfall at the start, which depends on the state of the SIT at the start, nor is there any question of popping back from V or W to U. That simply misunderstands the operation of the waterfall. And the point that's made by Mr. Wolfson in relation to that is, in our submission, simply a false one. And one can test it. If one is thinking of sums that are going down, well, in fact, Mr. Wolfson yesterday afternoon used the expression of euro by euro to the Class F Noteholders in connection with condition 3. He used that to illustrate the point that at the moment when the SIT was reached under the condition 3 waterfall, different things go to different places. Exactly the same applies here. The only difference is that you don't have an express reference here to the SIT, but you find that reference within the definitions that make up the incentive fee and indeed the termination amount. There may be many points that Mr. Wolfson has against me that my lords and my lady consider to be meritorious, but with the greatest respect, this is not one of them. If I could turn on then to the SIT, and this is the second of Napier's big points. In other words, that the proviso in the ICMF definition relating to the SIT means that principal payable on the redemption date does not count in determining if the threshold has been met. And Mr. Wolfson has, again, in our submission, failed to grapple substantially with the inconsistencies in his construction. And it's important to remember here, in this context, that the SIT is only relevant to ICMF and CMTA. It has no other role in the structure of the notes. And its definition, which you see at page 675 of Bundle B3 or page 138 of Bundle A specifically includes, these are points that I know my lords and my lady have, but it specifically includes interest and principal payable on every relevant payment date. That's what aggregate distributions are. And Mr. Wolfson's suggestion that that simply begs the question is fundamentally misplaced. Aggregate distributions can mean nothing other than the total of the distributions made to the Class F Noteholders. And it is illogical, and our submission frankly absurd, to say that this IRR threshold that you see in this definition can only be satisfied on the relevant payment date by taking into account interest payable on that date, but not principal. And the answer which Mr. Wolfson sought to give, that this was the deal, see the language used, is not only conclusory, but it masks the implications which he seeks to read into the proviso in the definition of ICMF, and the way he says it should be formulated. In other words, he says that prior principal and interest can count. So when you're looking at the definition of ICMF, and this is at page 697 or 140 of Bundle A, when you're looking at that and you're looking at the proviso in the last 3 lines, he says, well, it doesn't actually mean only interest to be paid on the payment date. What it means is, yes, you can take into account prior principal, you can take into account prior interest. It's not intended to exclude those. And furthermore, principal can be carried over to the next payment date. In other words, on his approach, it's a timing point, not an objection in principle to principal being counted, but with no explanation at all as to how this has any commercial sense when there's no other payment date because the notes have been redeemed and it's all come to an end. But the inconsistencies to be found in the definition of SIT are not, in our submission, the only inconsistencies in Mr. Wolfson's construction. And you will recall in particular that the condition 3 waterfalls refer to SIT on 5 occasions. And they patently so refer on every occasion, apart from one, to SIT in a sense which is inconsistent with Mr. Wolfson's construction. And the clearest example of that is at page 374 of Bundle B2. And this is the condition 3C2 principal waterfall. Top of the page, Z. I know a condition that you've looked at more than once. It's to the payment of principal on the Class F notes until the SIT has been reached. There is no limit in that. It clearly includes distribution in respect of principal of the notes as counting towards the SIT. And Mr. Wolfson has not been able to advance any explanation for this or other examples of the use of SIT in the way he says. Now what this shows in our submission is that the proviso in the ICMF definition isn't a limit or restriction. And indeed, if it were to be intended to be an exclusion of current principal payments, one can ask quite reasonably the question, well, why didn't the proviso say so? It is not exactly difficult to draft. It would simply say, and most logically it would go into the SIT definition, excluding restrictions on the relevant payment date in respect of principal on the notes. but instead what you have in the proviso is positive inclusionary language being used, from which you are asked to infer that current but not past distributions of principal are to be excluded. Now, faced with these difficulties and inconsistencies, and where the only place where the proviso is repeated in the conditions is in the interest waterfall at HH, which is at page 370 in bundle B2 and page 151 in bundle A. My lords will remember this.
So sorry, could you give me that reference again to the ordinary, not to the A1?
Yes, B2, page 370. It's HH at the bottom of the page, and you'll remember that it's X in the second line. It's II, not AA. Oh, I'm so sorry. It's II. I'm grateful to Mr. Wilson. And the obvious explanation, as I submitted yesterday in relation to this, so I'll take it very briefly, but the obvious explanation, because of the condition in which it is used, namely the interest waterfall and a provision within that waterfall which is operating a cap on the amount of ICMF payable, which then flows through to interest being paid to the Class F Noteholders. The obvious reason for that in our submission is that of clarity. Now, when one puts all those pieces together, the linguistic argument is simply not in our submission strong enough to exclude any income received by the Class F Noteholders, which happens to be paid in respect of the principal of their notes. And in this connection, I should pick up a further point made by Mr. Wolfson in response to our submissions that it didn't matter to the Class F Noteholders whether the return to them was by way of interest or principal. And I think Mr. Wolfson said we were wrong to describe their entitlement on an optional redemption as being to the surplus, in other words, what's left over at the end of the waterfall. But I should just show you, and perhaps I should have shown you yesterday, that that is exactly what the redemption price is, which is payable to them on an optional redemption. And you will recall when we were looking at condition 7b, if the note holders call for an optional redemption, they're entitled to the redemption price. The redemption price is defined in the master definitions at bundle B3, page 718. And the relevant part is subparagraph C, just below the first hole punch. So when used with respect to Class F secure income notes, redemption price means the pro rata share of the aggregate proceeds of liquidation of the collateral or realisation of the security thereover in such circumstances, remaining following application thereof in accordance with the priorities of payment. In other words, what redemption targets is you pull out everyone else, and this includes, of course, the ICMF, because that appears at U, and the Class F Noteholders are at V and W. So what they get is what's left, and that completely supports our submissions as to how that works through. Now, another point was made this morning, Mr. Wolfson suggesting in relation to the condition 7 mechanism that there's no evidence that it was actually operated in the way that it should have done. I think he's technically right that no one has actually said that in terms, but there is, we would suggest, a fairly strong influence from the fact of notices being given and the collateral administrator and the trustee proceeding with the redemption, that it was followed. But there's one other point that I should just respond to. Part of my submissions yesterday was identifying to my lords and my lady the commercial oddity of the situation where the collateral manager, as required to under condition 7b2, had embarked on the process of getting the requisite binding agreements in a very short period of time so that the confirmation could be given 5 days out, that 2 days before the redemption date, the cash would be there. Now, what Mr. Wolfson said this morning is, well, hold on, you would enter into conditional agreements. And so therefore there would be no question if you fall short by 10% because someone is playing up because of KYC checks or settlement dates. You'd have no difficulty in unwinding all the binding agreements should it turn out that you don't make the threshold. Now, there's no evidence at all before you that that is the way that it would be operated. And the point is, within the time that the collateral manager has, he has to take steps to enter into agreements. And the short point, which is thrown up by this, and there are a number of them within the documentation and within the way in which the transaction works, is that if he has entered into those agreements, but the redemption doesn't proceed, he gets the ICMF if it's otherwise payable. But if the redemption does proceed, in other words, he does the better job in one sense in this respect, he gets no ICMF. And the whole point of the submissions that I was making yesterday, that Mr. Wolfson, I don't think has actually grappled with, is the randomness of the way in which this works on his interpretation.
Well, I think he's making one more fundamental point, which is both in reality and as a matter of law, as a matter of the interpretation of the contract, there wouldn't be a redemption, an optional redemption by the note holders, unless there is a binding contract to sell all the investments, all the assets.
Oh, yes, absolutely.
So the idea of a shortfall is not realistic.
No, my lord, I'm sorry, I don't think I've communicated the point accurately. Mr. Wolfson and I are at agreement that you need confirmation from the collateral manager 5 days out from the redemption date that the binding agreements are in place and there's going to be cash 2 days out. Yeah. If you don't get that, there's no redemption. Yeah. But the question is, well, what then happens to those agreements that have been entered into to sell the assets? And the short point I'm making, it's the commercial one, the reality.
They won't enter into them. I'm so sorry. I think the point is that's being made is they won't enter into any binding contract unless they're sufficient to cover all the assets at the proper value that's necessary.
But, well, my lord, the difficulty...
We're speculating.
Well, in fact, probably not, my lord, because simply there are inevitably difficulties in relation to agreements, particularly when you're thinking of selling 100 different collateral debt securities with different counterparties. The short point is, if you do enter into those agreements, but one or two fall short of being able to provide the cash within the time available, or you don't cover 100%.
I understand the point, but you're asking us to make a point about the interpretation of this document on the basis of a hypothetical scenario, the likelihood of which is in dispute. I don't know if we've got any evidence about it here as to what actually happened here. And, we're not a fact-finding tribunal.
But Lord, I follow that entirely. I put it forward then on a hypothetical basis, yes, but one could see hypothetically.
Hypothetical issue.
And the same point arises under condition 10C. If I could just say a brief word about Mr. Miko's schedule, which was the large A3 document. Now, we accept, and we always have done, that if the notes had performed differently, distributions would have been made to the Class F Noteholders earlier, the 10% SIT would have been reached earlier, although after the time when optional redemption was possible in 2011. And if no optional redemption had been exercised, then on Napier's construction, we would have received ongoing ICMF under condition 3. Now that's never been in dispute. But the point is that simply doesn't answer the present question. In other words, whether we are entitled to an ICMF on an optional redemption. And on Mr. Miko's figures, I should also make clear that the effect of diversion to repay senior notes, in other words, the reduction you see on C, page 189 of 24.4 million euros, the effect of that was to increase the Class F noteholders' share of subsequent interest and of principal. Indeed, with careful management, which included realising some 20 million euros more than the default marks on defaulted security, the actual total amount received by the Class F noteholders is very close to the hypothetical amount that would have been received on Mr. Miko's run. And he doesn't, as you've seen, include capital receipts, which necessarily would be much lower because most of the capital would have been diverted to the more senior notes. But the overall result in terms of total income to the Class F noteholders is broadly the same. And the evidence has it in Mr. Faulkner's statement that the actual received by the Class F noteholders on optional redemption was about 113 million euros. On Mr. Miko's statement, or figures I should say, at page 190, you see his figure in respect of interest is just over 108 million euros. I'm sorry.
Years later.
Oh yes, this is a different. There's different time, but that's relevant only to the calculation of IRR. It's not relevant to the total return. If one makes the allowance for the diversion of capital and the amounts that would have to have been paid to the more senior notes, you would end up with about 5 or 6 million of capital going to the Class F noteholders, which is broadly the same ultimate result as they in fact got. And it simply emphasises, I think, one of the overarching commercial points, that if you have a performance fee based on cumulative income to the Class F noteholders and internal rate of return metrics, in other words, the internal rate of return to the Class F noteholders, they may be met in any number of circumstances and at any time during the life of the notes. But if they are met, on what conceivable commercial basis would the metrics be disapplied on an optional redemption? And we would suggest that such a result would need clear and consistent language in the documentation. And in our submission, the language used here doesn't get close to that. And applying the established principles of construction, the intellectual and linguistic contortion that is necessary to get there is simply not warranted or justified. My lords and my lady, with, I think, hearing the clock strike at 1 o'clock, unless there are any other particular matters that I can address you on.
Lady Justice Asplin, have you got any questions? Is she there? Lady Justice Asplin? She's gone.
Hello?
Oh, yes. Have you any questions?
No, thank you.
Thank you. So, thank you very much, Mr. Elton. We're grateful to all counsel and those sitting behind them who I know have played a great part in all of this. We will consider our judgments in due course in the usual way. When you get the corrections of grammatical and textual errors only, please agree a form of order. Any further submissions to be in writing unless we ask for all submissions. Thank you very much.
All right.